Here's a question, and there are several in this vein. Which of your opinions are you most proud of because of its impact on the court's jurisprudence?
Well, I haven't had that many triumphs in bringing the court back to an originalist view of the Constitution. But one area where I did was the Confrontation Clause. It's in the Sixth Amendment, and it says that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him, the so-called right of confrontation. This goes all the way back to the English Bill of Rights. And the English got really mad when Sir Walter Raleigh was tried for treason. There was introduced at his trial an affidavit by an alleged co-conspirator who was in France, saying that Raleigh was indeed a traitor. And Raleigh insisted that in the common law you cannot bring in this hearsay. Bring the witness before me in the tribunal, and he will recant what he says in that affidavit. The court did not allow it, and Raleigh's head was chopped off. And it was well remembered by the English. And that was the genesis of our Confrontation Clause. There's no doubt what it means. It means that the witnesses against you have to appear in court and say, yes, he did it. You cannot bring in a witness who says, Joe told me that he did it. You bring in Joe. Otherwise, it's hearsay. And that's not permitted. Okay. About 25 years ago, in a case called, what was it? Reynolds? Never mind the case.
When you know it, I get called on in class and I'm not prepared.
The Supreme Court, I think the opinion was written by Rehnquist, who was no originalist, and very much law and order. That opinion held that in order to comport with the Confrontation Clause, all that is necessary is that the hearsay introduced must bear, quote, indicia of reliability. And the lower courts were going nuts over, what does that mean? What are indicia of reliability? Well, I wrote an opinion for the court that overruled whatever that case was. You don't have to remember the name anymore. It's been overruled. That's why I've erased it from my consciousness.
Off the hook.
And
I'm not going to get any discretionary points, that's for sure.
And we said, made a lot of sense really, that the only indicium of reliability that can satisfy the Confrontation Clause is confrontation, which seems to be quite so obvious. It's such a simple-minded case, I don't know why I should be so proud of it. But actually, it did overrule what I had thought to be a real distortion of the Constitution. And it makes a good point that do not think that those who believe in an evolving Constitution do not think they're always going to be creating new freedoms and new liberties. No, it's a two-way street. They'll be taking away some of your old freedoms and some of your old liberties as well. And that's what happened with the Confrontation Clause. So we brought it back to what it should have been. And I was very proud of that. And that also answers the libel that originalists are really just law and order conservatives and they like originalism because it always leads in a conservative direction. It doesn't. It doesn't. Sometimes it brings back the liberties that later decisions have eliminated improperly.